Competition Commission of India or CCI had imposed a fine of 1,337 crore rupees on Google early this year for allegedly abusing its dominant position in the Android mobile device ecosystem. It had come just months after Google was found guilty of similar charges in Europe, and a fine was also slapped on it by a court there. And just a few months later, the National Company Law Appellate Tribunal or NCLAT upheld the CCI penalty on Google. The tribunal held that a number of Google's practices pointed to an abuse of dominance. But the NCLAT set aside 4 of the 10 conditions that the CCI had imposed on Google. It included preventing sideloading of apps and sharing Google's Play Store code with original equipment manufacturers. Now both the Google and the CCI are in the Supreme Court. While Google wants the CCI order to be quashed, the CCI had challenged part of the NCLAT order. In its appeal, Google said, had the tribunal applied the effects test, it would have found that Google's agreements were incapable of causing any anti-competitive effects. During its investigation, the CCI had approached industry players and asked if Google used its dominance. Amazon, which was among them, told the CCI that Google's dominance hindered the growth of its Fire OS. Amazon also appeared before the CCI as witness in July 2022 when the competition watchdog asked industry players, including Amazon, Mozilla, and device manufacturers, during the probe against Google. Amazon had claimed in its submission that it had experienced significant difficulties in finding OEM partners to manufacture smart TVs running its Fire OS due to Google's Android compatibility commitment clause. Amazon had also informed CCI investigators that the creation of Fire OS as a forked Android system required substantial resources, including thousands of employee hours. Google, in its appeal, had targeted Amazon, arguing that the CCI unjustly relied on Amazon's complaint when making its adverse decision against Google, stating that Fire OS had failed commercially on a global scale and was not even launched in India. However, experts believe Google has been aggressive in its appeal against CCI.
You have a tendency to adopt different sets of standards in Europe and different sets of standards in India. So that is the crux of the matter. Google has a tendency, with due respect to them, to be slightly unduly aggressive against the regulator itself. It is not only Amazon. If you look at the order of CCI, there were several others who have similarly contended before CCI. These included, besides Amazon, Mozilla, even Microsoft, including even Alibaba and so on. They were all biggies. So they have all said that Google had become dominant. CCI, as a very matured and neutral, objective regulator, they have been taking a stand, relying on what has been done in other jurisdictions also, including in Europe. So what they have done is absolutely in order, it's correct.
So with Google's counter allegations, what are the implications of inviting third-party submissions in such a case?
In all such cases, and in fact in all cases that the CCI looks at, third-party submissions are relied upon and are central to the investigation. The reason for this is that under the structure of the Competition Act, any person, whether or not they're an aggrieved party, can file that initial information. And if a researcher, as in this case, who filed the information, may not have the same kind of information or input or detail to provide the commission as players in the market. So once the investigation starts, it is the role of the Director General's office to in fact reach out to these third parties and get this input from them, as these third parties are best placed to answer the question, is Google's abuse of dominance impacting the market? And so this case, there's nothing untoward about relying on third-party submissions. It's fairly standard.
However, what is curious in this case is, and that's what has been highlighted by Google, is that it just relied on certain competitors, namely Amazon, while it did not take comments from OEMs like Samsung, Sony, and others who are actually in the same space or developing an Android fork.
Does the CCI's handling of the case send out any negative signals for the larger competition ecosystem in India?
The CCI is very interested and is looking at big tech generally. The government is very interested and has started the process of passing a digital competition law. I don't believe this is the CCI either getting caught between two technology giants or favoring one over the other. The CCI was doing its regulatory duty in reaching out to competitors in the market and potentially interested parties in finding out what the lay of the land is.
Experts believe, therefore, that with the fast-growing tech ecosystem in India, multinational giants like Google will have to understand and eventually accept the larger regulatory atmosphere that regulators like CCI have enforced. On the other hand, given the push for tech innovation and manufacturing in the country, regulators like CCI will also have to make sure that the structures are not too rigid. So the current case is merely a stage in the evolution of India's tech industry ecosystem, they believe.
If you like this video, share it and subscribe to Business Standard. For more news, views and insights, log on to www.business-standard.com. Do also follow us on YouTube, Twitter, Facebook, Instagram, Telegram and LinkedIn.
She's working her way to the corner office. Business Standard.